Well, I'm going to get us started just so we can keep on time. Good afternoon, everybody. My name is Paul Rose. I'm the dean here, and welcome back. I think we have a number of faces that have been with us throughout this series. This is, of course, the Stephen S. Kaufman Family Anatomy of a Trial lecture series at Case Western Reserve University School of Law. This program has really become one of our signature offerings already in its first year. It was designed to help bring the realities of trial practice into sharp focus, to give our students, to give other practitioners the ability to see folks who are really at the top of the profession and see how they think through a trial, prepare for a trial, how they perform in a trial. And this session in particular continues that immersive approach by walking through a case, showing you how strategy can unfold from one phase of the trial to the next. We're going to have lectures tonight and then demonstration tomorrow. And of course, none of this would have been possible without the generosity of Steve Kaufman. Steve, we are very proud to say, is our alumnus. But he's also, of course, in his own right, a very distinguished trial lawyer whose career reflects the excellence that this series is designed to showcase. And he was really committed to bringing a practical legal education to our students and to the broader community, and really wanted to make sure that our students would learn from the very best. And again, we're so grateful that he has made this program possible. So Steve, thank you for your leadership and your support. So now I'm going to turn it over to Steve. Steve is going to introduce our guests, and we will get going. Thanks, Steve.
Dean Rose, thank you very much. And the Dean, among others, Laura McNally and Jen Kupar, has been an incredible supporter of our efforts. It was the first year. We had a lot of things to work through, and the Dean and his team have been extraordinarily effective at what they've done. So I really appreciate their work. Thank you. This is a labor of love to set up this program, to fund it, because my goals were twofold. One, to really help teach, as the Dean said, a next generation of trial lawyers. And second, to offer something back to the community that I had the pleasure and privilege of being a part of, the legal community, and the trial work I did with colleagues. And I found at every program I've been to, I've learned something, and we wanted to make this available to the practitioners in Cleveland as well, to give them the same chance. So those were the things that I had in mind when I did this. But why? I really thought about this before I did it, and I concluded that the world we're in is an incredibly different world than I walked into as a graduate of law school in 1975. The world's changed, law has changed, and trial work has changed. So that was my starting point. But when I thought about it, was really, to me, about like what I see every day, every week in the news. TV, print, commentary, podcasts, the things that are happening in the law, whether it's a constitutional rights issue, civil rights issue, elections, fiduciary duty, commercial cases raising incredibly important questions that hadn't been tested before, government authority, all of these things are crashing at us. Every one of them has presented legal challenges to situations or legal fights to achieve something, and every one of them has required great trial lawyers to win the day or prevent something that others felt should not have been won. That's what the difference is, and I feel that that trial lawyers are the firewall for all the things that I've mentioned. So with that said, that's why I did this, and I'm really glad I did. So tonight, we have, and part of this program was to bring in national talent, national successful trial lawyers from around the country. I didn't have to go very far to find some of the best, and we have two of them here tonight. So it's my privilege to at least tell you who they are. Eric Kennedy is behind me. There's Eric over here. Eric graduated this law school in 1980. He has been practicing at Weissman, Kennedy, and Barris for 30 years. He practices in the area of pharmaceutical and medical device liability, medical malpractice, and class actions. And these are the things that, again, I could go on for an hour here to go through all this stuff, but I just want to hit some of the highlights to me. Eric, best lawyers in America since 1989. In 2000, listed as the National Law Journal one of the best 10 trial lawyers in Ohio. 2009, recognized as the Personal Injury Litigator of the Year, and also for Cleveland in Best Lawyers. Most of his career has been devoted to individual clients, but he also sat on the National Settlement Committee in the breast transplant litigation, was trial counsel in the Telectronics pacemaker class action, where over 20,000 cases were consolidated into a single federal court. He was the lead and class counsel in the Sulzer prosthetic hip and knee litigation, where he was instrumental in resolution of over $1 billion. He's an invited member of the John Manos Inn of Court, the International Academy of Trial Lawyers, American College of Trial Lawyers, the International Society of Barristers, and in 1918, Eric received the Clarence Darrow Award for his accomplishments as a trial lawyer, and then was inducted into the Trial Lawyer Hall of Fame in 2019. I could go on, but you get the idea. This is a career of incredible success and recognition for his success, and we're very fortunate to have Eric here with us tonight. The second is a lawyer who's not only been a friend but a partner of mine for a number of years as I practiced at UB Greenfelder with Mike. Mike is a 1984 Boston University law grad. He is the chair of the law firm's litigation department. He's nationally recognized as a trial lawyer in a variety of areas, commercial and financial services. He represents clients across the country in a broad range of matters, including defense of commercial banking, professional liability, securities, broker-dealer, class action, consumer product liability, pharmaceutical, and medical device cases. He could do all of that. And I know Mike, he has to learn these things and learn about them to be effective as a trial lawyer. It's remarkable that he could have that range. He's recognized in Chambers USA as America's leading lawyer for business from 2007 to 25. He's ranked in band 1 of Chambers in general commercial litigation, and only 6 other Ohio lawyers in that group. He's been selected as one of the top 100 trial lawyers in America by Benchmark, and he's been successfully recognized by Law Dragon 500 leading lawyers in America from 2003 to 2006. Mike's done a lot of other things in the community, including being the past president of the Cleveland Bar and being the past president of the Cleveland Legal Aid Society, where he served for many, many years on the board of directors. We could not have 2 better trial lawyers nationally than we have here tonight to teach and to help us learn. So with that said, I'm going to turn this over to Laura, who's going to kind of introduce us to the program, but I want to thank these gentlemen right now for being here.
Thanks, Steve. You don't want to hear from me, you want to hear from them. So my job is short and sweet. I just want to tell you quickly what the case is about, just the premise. The document is also out on the table, but this is a NETA problem set that we're using for the demonstration portion of the 3 sessions. So we did the opening last time, and we'll do the closing next time. And so this is about a community divided. And at the heart of this case is it's a civil litigation case involving toxic dumping. McNamara v. Energy Dynamics, Inc. is a civil case for negligence pitting a local dairy farmer against a large energy company. Defendant Energy Dynamics, Inc. specializes in hydraulic fracturing, better known as fracking, and came to NETA years ago to begin exploring for natural gas in the Columbia Shale. Energy Dynamics has developed a new chemical. This breakthrough unlocks precious resources and untold millions of dollars buried beneath the local community's feet. But McNamara experiences, that's the farmer, experiences mysterious livestock deaths at his dairy farm. Will the breakthrough from energy dynamics prove to be a dangerous breakout of toxic chemicals? I think that was probably written not in the most favorable way to the parties behind me, so we'll see what they take umbrage to. But that's it. That's what the case is about, and I'm going to turn it over to the speakers for the rest of the program.
Good evening, everyone. Again, my name is Mike Unger. I want to take a point of personal privilege. I want to thank Dean Rose. I want to thank Case Western Reserve University. And most importantly, I want to thank Steve Kaufman for making this program possible. I've been at all the programs. I think I missed one, and I can safely say that I think you have hit it. I think you have fostered what, in my view, is a singularly unique platform and environment that helps prepare lawyers of all walks, those that are just starting out, and those that have, like many in the room, who have tried more than their fair share of cases for the rigors and the rewards of the career that we as trial lawyers have chosen. So needless to say, it's a real honor for me to be invited to and participate in this program, including with my friend, Mr. Kennedy, who's behind me. So again, thank you for the privilege of being here. Let me tell you our planned approach, and hopefully it's okay with you. I don't know that you have a lot to say in that regard, but what Eric and I talked about doing, and he gets the credit, and he was absolutely right. We first talked about how we're going to cut at this thing about a month ago. Eric said, you know what, I think on Friday night we ought to both get up there and talk about, give the audience our views of what a good direct examination of the company CEO looks like, and then following that, what a good cross-examination of her looks like. And that made a lot of sense to me, and that's what we're planning to do. So we're each going to get up here and be the proverbial talking heads for about 45 minutes or so, and someone should watch me and give me the proverbial hook if you could do that, Sophie, that would be great, when I approach, because I don't want to infringe on my friend's time. And then we'll open it up for Q&A. So initially it will be generic, and then tomorrow you will see a demonstration of a direct examination of M.K. Phelps, who is the CEO of the accused company here, Energy Dynamics, and then you will see a cross-examination of M.K. Phelps as well, and hopefully it will be illustrative and entertaining and educational all at the same time. Okay, any questions before we get started? And again, if you can just hold your questions until the end, unless it's a burning question, and we'll plow through this. All right. I like to begin with a joke. I'm going to give you my opponent's slide. We're going to have a little bit of levity in here, and it's really hard. Let me just parenthetically note that this isn't an easy task, because as Dean Rose noted a few moments ago, Steve and the team here lined up a phenomenal lineup, and this thing started with none other than Mark Lanier, right? And you'll see I'll pay a little bit of respect to him in my presentation, but the presentations have just been phenomenal. And I will try, for those that were here, and I know I see a number of my friends who I know were here the last time. I apologize, the law student faces may not look as familiar to me, but I will try to follow Luke Deschaux's presentation on behalf of the defense, the opening, as much as possible. But I promise you it won't be perfect, because I didn't have his notes, and I wasn't able to get a hold of his PowerPoint. So, for example, I don't have his timeline with respect to the direct exam that you'll see tomorrow. Okay, so let's just talk a little bit about the purposes of direct examination. And when you're talking about a direct exam of the CEO, this is your opportunity. Under the NIDA approach, we each only have two witnesses, and this is your opportunity to tell your story through a witness. As I'll give away a little trade secret, as I've now coached Sophie, who I know is going to be a terrific witness tomorrow for us. The plan is that I will be here or here, and I'll be talking to her. Your focus will be entirely on her, and she and I are just going to be having what, Sophie? A conversation. We're just going to be having a conversation surrounded by the judge. Judge Sennenberg will be seated right there, and opposing counsel, and you, the jury, will be listening to us have this conversation. What's the purpose? We want to tell the jury a little bit about our story. We want to de-vilify the company. We want to de-vilify its CEO, Mr. Kennedy, and his predecessor, Ms. Peterson? Peterson? Yeah. Ms. Peterson have done an excellent job thus far of calling into question the bona fides of this company and the integrity of this company, and we need to deal with that and deal with it straight up. The purpose of tomorrow, as you will see, is to advance our case theory, and again, it's gonna feel a lot more if I do it right. We'll see if I do. If I do it right, it's gonna feel a lot more like a conversation than an interrogation, okay? Who's this witness to the jury? This witness does not need a lot of introduction to this jury based on what's happened thus far. They're gonna be looking forward to hearing from M.K. Phelps. They know who M.K. Phelps is at this point, and they're gonna be judging her almost immediately. And one of the things, and I'll be interested in how you size things up, and we'll talk about this hopefully tomorrow, is what kind of credibility does the witness bring naturally? And all the trial lawyers in the room are going to smile when I say that, because they all know what I'm talking about, right? There are some witnesses, when you meet them, they may be brilliant. They may be debonair. They may be great storytellers, etc. But you know you got a problem on your hands, right? It's one of these classic Houston, we got a problem. We got to figure out how to turn a high caliber, high performing CEO into a good witness. That can oftentimes be a challenge. It's not a challenge, to be perfectly honest, with respect to Sophie, but oftentimes it is, and you need to, and another point that I would make is this meeting that you're having to size up the CEO as the witness, your star witness, in a case ought not be happening the day or two before trial. This ought to be happening many weeks, if not many months before trial, so that you can assess how much work needs to go into getting this person ready. What are the weaknesses in the case? You know, when you've got opposing counsel like Eric Kennedy, you're a fool if you don't anticipate and expect that the weaknesses in your case are going to come out and are going to be exploited. And it doesn't mean that you deal with every single one of them in your direct examination, but you're foolish if you don't deal with some of them, and you will see that execute tomorrow. Hopefully I've anticipated correctly. And again, in this NIDA program, what role does this witness play in your overall story? The answer is pivotal. I mean, she's got a huge role in the overall story, and you have to cover that. That militates in favor of covering an awful lot of ground. So we talk about meetings well in advance. Make sure that the hot documents, both hot documents that you envision as being hot, as you envision as being important, if your team members are saying, hey, these are the documents, Unger Kennedy, that you got to cover with this witness, make sure that the witness is seeing those well in advance. I would say well in advance of the prep. Find out if there are any that give the witness any undue amount of angst. Find out from the witness if he or she is aware of any hot documents that you aren't showing them. Things, we're not perfect, and there may be things that he or she knows about that they're a little surprised. I did that with Sophie. I said, Sophie, tell me if you think there are any key exhibits in this case that you think we didn't cover. I am a fan. I'm going to give away a trade secret here for all the lawyers that I've opposed for all these years, and plenty of them are in this room. I use an incredibly dated video, like so dated that I'm pretty sure it initially came out in VHS format. It's a video put together by the Debevoise firm in New York and first put out on the marketplace by Matthew Bender, if I'm not mistaken. And you'll see it, and I'm about to show you the cover for it. It's available now for free on YouTube. I don't know whether you're infringing on anybody's IP rights or not, full disclaimer. But it is the best prep instrument I've ever come across. So, and I've seen every single one. I guarantee my law firm has bought every single one and rolled them out. But this is the absolute best. It's called Preparing for a Deposition, and it works because it is in the business context. So there are some witnesses that it wouldn't work with, but if you have a CEO who is about to be cross-examined or direct examined in trial, there is no better teaching tool, I submit, for deposition or for testimony than this video, which again is very dated. I would say it's circa 1970s, maybe 80s, earlier, I don't think it's 60s, but anyway, it's an old video, and each of the vignettes is extremely entertaining to drive home the point of the do's and do nots. If you haven't seen it and you're a trial lawyer, you should see it and make use of it if you think it fits for you. Okay, so let's talk a little bit about the specifics of a direct examination, right? A little bit of educational background, professional experience. And you'll see this tomorrow, what was your path to the top? How is it that you advanced and became the CEO? If you had prior roles at the company, what were they? What was your exposure to various lines of business that the company has? What do you do as CEO? And this is all the trial lawyers in the room know what we're talking about here. This is all part of humanizing the witness in front of the jury, and they're getting to know her. When I say think in chapters, not questions, what I mean is this, and anybody who wishes to do it, some in the room have prepared direct examinations for me, some have prepared many direct examinations for me, so they know that I think in terms of chapters, everything has a header, right? Everything has a headline, and then the questions that we are considering asking follows. Very simple, straightforward structure, background and orientation, what happened and why it matters. Doing it in as much as possible, a logical chronology, a very linear way, makes sense because it's easier to follow. And again, quoting Mark Lanier and everybody else who's been up here, it helps tell the story from the company's perspective. Okay. Sometimes you get these CEO types, right? And if you click on that earlier tape that I talked about, you'll see this. There's a don't tell me what to do or how to do it CEO who starts out. He's the CEO of a company called Corrosive Chemical, and nobody's going to tell that CEO what he's going to do or how he's going to do it, and he's not going to answer a single question. Right? He's not going to answer the question correct in a correct way. And the bottom line is that you need to take some control with that difficult CEO and explain to her or him that at the end of the day, you're not going to express a lot of displeasure, to be sure, in the courtroom, but you are just looking for him or her to answer the question. And if you don't get a straight up answer to the question, I can assure you that Her Honor is going to direct the witness to give a straight up answer to the question, whether that question is coming from me or whether it's coming from Eric on cross-examination. Okay, back to some specifics when you're putting a direct exam together of the CEO. Talk a little bit about the business, the industry, the products that it serves, a little bit about the size of the company, humanize the company a little bit, be clever, don't be clever, but be very clear in your responses. The company's reputation and standing in the industry is important. In this context, some of the dialogue that happened between the company and the NEDA inspectors who visited various company sites for a little bit of better and for a little bit of worse is going to be extremely relevant, and we'll get into that tomorrow, and you'll see it play out undoubtedly with Olivia's examination. You can have the greatest script in the world. I might have prepared a script and sent it to Steve Kaufman and asked him to review it, and he might say, Mike, that's great. Anybody who shows up at trial and thinks that that script then is gonna be your roadmap is foolish, right? Because things are gonna happen. There's gonna be zigging and there's gonna be zagging. There's gonna be interaction prompted by Mr. Kennedy. There's gonna be interaction prompted by Judge Sennenberg. There may be rulings prompted by Judge Sennenberg that are going to cause you as the examiner to need to call audibles as you're going along. And you need to be ready to do so. And you can't be tied to an outline, right? You need to listen to your witness, and you need to listen carefully and actively. And you got to start with, how are you relevant here? How did you become aware of the subject matter of the lawsuit? This particular situation is a very high-profile matter, and the company's CEO is intimately involved in almost every aspect of it, so it lends itself naturally to a timeline that will make a lot of sense tomorrow. Some of the decisions that she made with respect to the rollout of this product issue, Tetro, are going to be very, very important. And scope of authority is not all that relevant here. Sometimes it is, oftentimes it is, and oftentimes you don't wish to immerse your CEO in decisions that were being made by people at a lower organizational, lower level on the org chart. You're dealing with the CEO, you're talking about what we call an apex witness. But in this particular case, under this fact pattern, she's intimately involved in a whole bunch of discussions that are relevant to what we're talking about. Depending on your judge, there's a little bit of know your judge here, but generally speaking, you are safer if you are asking direct and open-ended and non-leading questions. You are safer. Occasionally, and I have a tendency to do this, occasionally you think that a couple of questions can be combined into one, but you run the risk, particularly in cases like this where there's some science, there's some technology, there are things that are not everyday experiences that a jury may necessarily naturally follow, where it's potentially confusing if you are burdening the jury with multiple facts in response to the question. So I would generally urge you to err on the side of caution and try as much as possible to limit it to one fact per question. The urge to interrupt. Anybody who knows me knows I have a constant burning need to interrupt. Almost, and especially when I'm cross-examining. Don't do it on direct examination. Once you're done and you have your direct exam question out to your witness, even if you don't love it, and even if you want to take it back, let him or her answer the question, assuming they understood it, and let it play out. The other thing that you have to be ready for is occasionally you think best laid plans, right? You say, well, I spent hours with the witness prepping her, and so this is going to go down smooth as a vanilla milkshake. There's not going to be any hiccups along the way. How could there be? I've done a phenomenal job preparing the witness, and then the witness has a brain cramp, right? And it happens to everybody, right? And you are responsible for getting the witness back on track. And the best way to do that is to actively listen to the witness, let the witness speak, and then work with him or her. A well-prepared witness will easily be able to get back on track. But it requires a lot of active listening. I object. Counsel is trying to confuse the jury with the intent of the law, completely ignoring the loopholes and the technicalities of the law. All right. Let's talk about, we're going to open it up a little bit to not this case, because this case is not a contract dispute. It is, best I can tell, it's a simple negligence lawsuit. I think it's a one-count complaint for negligence. All right, well, see, we didn't coordinate on this, and he's a step ahead. So if it's a contract dispute, make sure you cover with the CEO her or his role in negotiating the contract, approving the contract, reviewing the contract, having legal counsel, in-house legal counsel or outside counsel review and cover the execution of the agreement and the CEO's understanding of the material terms at the time, and the steps that were taken to ensure that the contract was performed in accordance with its terms. And things obviously changed. If things didn't change, we wouldn't be in litigation. So what changed? Where did things go awry? How and why? And how did the company respond to that? Getting a little closer to home, assuming Eric doesn't beat us up too badly on this. If it's a tort or a negligence or a fraud or misrepresentation claim, you like some of those terms, right? Okay. What representations were made by whom and in what context, and what does this CEO know about certain things? And you'll hear me do this tomorrow in the mock exercise. Most importantly, in a case like this, what things didn't the CEO do? What instructions weren't given to employees, whether it's to interfere with the NEDA inspectors who were coming on site to inspect the various locations, including the pits, whether it's the inspector who came on site to issue a citation for certain environmental violations with respect to the pit. What observations were made with respect to Mr. McNamara's adjoining property and the condition of his cows and things of that sort. The CEO's knowledge of and involvement with the alleged negligent conduct, as alleged by plaintiff, I suspect that my friend Mr. Kennedy will spend a fair amount of time on this tomorrow, because there was a fair amount of internal email discourse as this Tetro product was being developed. It's most unusual, I will tell you, but that's what you get when you're dealing with a NEDA problem. I mean, the CEO is actually hands-on involved as this product is not only being developed, it's a revolutionary product, but as it's being developed and as they're talking about the rollout. And there are going to be certain statements that I suspect Eric will want to talk about, and again, back to the point earlier, you'd be foolish not to address them. In my opinion, you'd be foolish as a defense lawyer handling the direct examination of the CEO. You'd be foolish not to elicit some preemptive testimony in that regard. And again, you'll see that play out tomorrow. Okay, a little bit. This is aimed. How many law students in the room, and how many people who have never tried a case? Okay, all right, a decent number. the bottom line is, you're all gonna have your first trial, right? We all had our first trial. You had a first trial, right? You probably remember it. I had my first trial. I remember it. Here's what
I had my first trial 8 times.
There you go.
If you always tell the jury, this is my first trial.
Exactly.
Well, my mistakes. I did it 8 times.
He steals my thunder. I mean, that's exactly the point. My take is a little different, which is you can only do it once, and you can only get away with it. You can only get away with it once. But when you have your first trial, or maybe even your second trial, take advantage of the fact and let them know that you haven't done this before, as I'm sure we all did. All right. In an employment discrimination case, there's plenty of employment cases out there these days. To the extent that the CEO is involved in the relevant HR decisions that went into the employee's likely termination or discipline, make sure you cover those. Make sure your CEO is ready to defend whatever he or she offered by way of input. The various, it's not just the CEO's view of what's right, but what's the important business reason for the decision. And of course, you want to, as much as possible, fit without shoehorning too much, fit the company's policies in such a manner so that it's clear that the termination was consistent with promoting the very logical company policies. Okay, this is Mr. Kennedy's favorite part and my least favorite part. Fortunately, this isn't a punitive damage case. At least I don't think it is. There's no claim for punitive damages. If there were a claim for punitive damages in this case, I would have a separate section of questions for direct examination of the CEO that would be designed to blunt a punitive damages claim. Here, however, there are going to just be claims for damages by Mr. McNamara for the damage sustained by his business, his bed and breakfast business, the damage to his herd, the deaths of his cows, and the damage to his dairy farm business. Once again, if you have a CEO, very unusual that your CEO would have a whole lot to say about this. Your expert witness is probably the one who would be on the receiving end of these questions. But everybody knows what the KISS principle is, right? You got to keep it real simple, and you got to keep it real straightforward. And if you can't explain to non-lawyers at the dinner table or the breakfast table the points that you are trying to make, you better go back and do it again, because that's the level that you want to attack it at in front of that jury. You want to ask open-ended questions. What did you do? How did you do it? What calculations were made? If you represent the defendant that is being accused and there is an opportunity to do so, you want to point out that certain steps were taken in order to mitigate any potential damage. You will see this happen tomorrow. You want to walk your CEO through the key exhibits in the case. We will do that with respect to each one. In many respects, the exhibits will become part of the timeline and part of the narrative for tomorrow. When the CEO is actually involved in some of the narratives, you ask the question, did you send, receive, or approve this? What was your response to it? What did you mean by it? If he or she is the spokesperson, what happened thereafter? Again, your classic for those that haven't tried cases or been through a trial ad course: who, what, when, where, why. All the W's are the types of questions that you want to be asking. Especially if you're in front of Her Honor tomorrow, who will otherwise sustain, I highly suspect, will sustain any attempt by yours truly to lead a witness. And believe me, if I think that I can get away with leading a witness, I do lead a witness, right? I will try every single time. You'll see me try a little bit tomorrow. We'll see how far I get. He'll object. I suspect she'll sustain some of the objections, but I want you to see that happen. If you're able to get away with it, my coaching, which some would disagree with, my coaching is that to the extent that you can get away with it on important points, that you try to lead your witness a little bit. Okay, and then of course a little bit of tribute to Mark Lanier, who played lots of, maybe not lots, but several vignettes from My Cousin Vinny, and everybody knows about that great performance. Okay. Your exhibits should help you clarify the testimony, anchor everybody's memory, reinforce key facts. Don't show too much. If you overshare, if you overshow, things get diluted, right? People only have so much capacity. Mark Lanier, how many people were here for Mark Lanier's program, right? A decent number. So everybody knows they only have so much capacity to absorb so much, and if you oversaturate, you run the risk of losing the great points that you otherwise made. I try not to just sit there and read documents to the jury. That said, occasionally, and you'll see this tomorrow, occasionally, do I have 10 minutes left? Okay, thank you. I'll be done before then. You will see there are certain things in certain documents where I think that they are wicked important, and I will read the language that I want Sophie/MK to focus on tomorrow, and I'll just leave it at that. You'll see that happen. But otherwise, don't sit there and engage in a jury reading line by line of the exhibits. There are some PowerPoints. Eric, I'll give you a sneak preview of what you'll see tomorrow. There are some PowerPoints from a public meeting that happened in the great state of Nita. Here that I think are important, and they in and of themselves, each one, help tell a story and help humanize the company here. And I'm going to let Sophie kind of take them and use them and she will be narrating what they show and what they say. But the exhibit really speaks for itself. Okay, and then for Mr. Kennedy. Tomorrow, right, Megan, will you please prepare our client for cross-examination? You know, when you have someone like the CEO, even if it is someone who presents the way Sophie presents, you can be sure that a great lawyer like Eric Kennedy with these facts is going to be coming after her. Okay, it's not a matter. It's just, and he's a very nice guy too, but not when he's got his boxing gloves on. And he's going to come after her, and she needs to be ready for that, right? You can't have her, you know, having met him in the hallway, having had some interaction with him, say, "Oh, what a nice guy. What happened to the nice guy?" That can't be a surprise. She needs to be prepared. I submit that the best prepared witnesses have gone through a little bit, and we've done a little bit of this, a little bit of mock cross-examination where you attempt, as the direct examiner, to impersonate your adversary as much as you can in order to get her ready for what's going to be a pretty punishing cross-examination. In this case, you'll decide whether we did it well or not. On multiple occasions in my mock, I have the CEO directly addressing and directly denying some of the key allegations that Mr. Kennedy and his client are making against my client, and constantly trying to, again, humanize her, humanize the company, and show good faith at all times. There also are a couple of imponderable facts here. Strike that. Maybe not imponderable, but difficult facts here, all of which were hit on by Luc Deschaux last go around for those that were here about a month ago, and those I can promise you will hear vestiges of those points in the direct examination. Covered that. Look, changes in policy and personnel and practices, mostly reserved for a punitive damage case, because you got to be careful if you're up there, if you're doing what we're doing, and you're defending and you're talking about any changes. Mr. Kennedy will get up and use that against you and say, look, these are admissions that what they were doing before weren't right, and you just need to be a little careful in that regard. Okay, a little bit of Tom Cruise. At the end, I always like to wrap up, and I try to wrap up with an apex witness like the CEO on a strong note. I don't do this with every witness on direct examination, and certainly some of the lower level employees. I don't do it at all. I just finish. But with Sophie tomorrow, I'm going to try to end on a high note and reinforce the defense narratives and the defense themes that I think work best here. And you should always know what the goals of the direct examination are, right? I mean, I like to say, those that work in my office will laugh when they hear me say this, right? I mean, before you figure out all the things that you're going to use to get to your destination, don't you need to come up with a roadmap? Don't you need to know what the destination looks like, right? So think about it before you sit down and start putting pen to paper and figuring out where you're going. And you should always know what your goals are of the direct examination before you start, and most importantly, before you ask that first question. Okay, those are 10 points to think about. Oh, let me talk a little bit about prep real quickly. When the witness assures you that he or she has done the prep that you asked them to do, say in my case, it involves the witness reviewing a videotape that I have sent to her. In this case, I know she did because she promised me she did. She watched it last night and enjoyed it. But that's not the end of the prep. When you get together with them, you want to make sure that you take that thing out for a test drive, and you want to make sure that you go through point by point, line by line. Now, I do tend to cheat a little bit, and I think that you could probably ask some very fine trial lawyers who are in this room whether they do what I do, and maybe only half would say they do what I do. But I take an outline, and it has the cue, it has the question, and it has the answer that I'm looking for. And I go over every single one of those questions with the witness. Now, at the end of the day, the witness, what's the most important thing the witness is told to do when he or she is giving testimony? What's the most important thing? Tell the truth, right? So no matter what, if he says, did Mr. Unger tell you what to do? Oh yeah, Mr. Unger told me what to do, told me to tell the truth. Right? So, and the witness is going to tell the truth. But the witness also needs to be hearing, especially some of the more challenging questions, not for the first time, right? Like, I don't care how smart you think you are. I don't care how smart and talented you think the witness is, how much you think that witness should be capable at adapting and understanding where you're going with those questions. I think it's dangerous and far exceeds my appetite for risk to be winging it, and that doesn't mean I'm not going to mention any names here, but I'm mindful that there are some great trial lawyers out there who say, look, in order to just get up there and have that conversation that you preach about, Unger, it can't be that rehearsed. It's going to sound too rehearsed if you sit down and go over things with the witness in the way that you're describing. We'll see about that tomorrow. We'll see how rehearsed it sounds, and if it does, we'll talk about that and welcome the thoughts. Okay, that's it on my end. How did I do on time?
Very good.
All right. Now you hear from the great Mr. Kennedy.
I was going to thank Steve for inviting me, but he's left. Thank you, Steve. knows what's to come. I guess at this point, I'm the only person standing between you all and happy hour. So I either ought to be really brief or extraordinarily entertaining. I don't tend to be either. So I guess your saving grace is that, other than my partner up there, Brian, I probably want to get to happy hour as well as anybody here. So cross-examination. Cross-examination is my topic here today, and I'm going to be way more generic than my. In my estimation, cross-examination is the most important part of a trial, and not because it's my topic here today, but because if you ever sit and you listen to a trial, and you get to the end of the trial and closing argument, you see the plaintiff stands up, and the plaintiff talks about nothing other than what he got on cross-examination from the defense. The defense lawyer stands up and talks about really nothing else other than what he or she got from the plaintiff's witnesses on cross-examination. And it's true for two reasons. One, because if I get something good from somebody else's witness, it's going to carry a whole lot more weight. Secondly, if I destroy the credibility of one of my opponent's witnesses, that lack of credibility permeates their entire case. You don't have a lack of credibility here, but your truth here. As your parents told you always growing up, hey, you lie once, you get caught. From that day forward, even when you're telling the truth, nobody's going to believe you. That's what happens when you cross-examine a witness in somebody else's case, and you destroy their credibility. So cross-examination, to me, is the most important aspect of the trial. Now, cross-examination, what are we doing? What is the goal of cross-examination? And I don't think that the goal, it's not Perry Mason, it's not TV. The goal is not to really establish this final point, this point of view, this fact, this winning fact. I've never cross-examined a witness where they suddenly looked up at me and said, "Oh, Mr. Kennedy, you're right. I changed my mind. The light was red. You're right." That doesn't happen. If that's your goal in cross-examination, you're not going to have an enjoyable career. What I have found, and really when you think about it and you look, the real goal of cross-examination is to attack and prove the lack of credibility of the witness. That's your goal. And if you make that your goal, it's achievable. You can be successful. And when you look at it, there's some fine lawyers here, and I would say to you, go back and look at your cross-examinations you've done. Look at the ones you're preparing now. And what I really realized that my cross-examinations are really just establishing inconsistencies that undermine credibility. The first inconsistency that's very common, it's the low-hanging fruit, is prior inconsistent statement. The witness comes and they testify A at trial, and you have a prior statement B. Might be in their deposition, it might be in an email, it might be in writing. It's just they said A and you bring up B. The low-hanging fruit. It's easy. I would say to you, make sure it's really inconsistent. It can't be close. Dan Getz will tell you what we call in our office, it's clean. It's absolutely inconsistent. If it's a close call, the witness is going to look at you, they're going to go, hey, that's what I just said. The other side's going to say, objection, that's not inconsistent. The judge might even jump in and say, Mr. Kennedy, move on, that's not inconsistent. So now he's lost credibility. The lawyer's lost credibility, not the witness. That's the low-hanging fruit. The second form of inconsistency is that the witness, their testimony is kind of inconsistent with other witnesses in the case. So Mrs. Smith said, she testifies, well, the light was red. You can say, well, you said the light was red, but you understand that, you were the 10th car back from the intersection, and the driver, Mr. Jones, in the second car, he says it's green. And you knew there was a pedestrian there, and they were standing on the corner waiting for that pedestrian sign to change, and they disagree with you too. So other witnesses, another form of inconsistency. You have authoritative treatises, which is basically a writing, a publication, a scientific article, a medical article, and it states something that's inconsistent with what the witness has said. In Ohio, in the federal system, any treatise, any publication that any witness in the case says is an authority can be used for cross-examination purposes. Now, implicit inconsistencies. That's kind of surrounding evidence. Surrounding evidence in the case that you're able to establish is inconsistent with the position the witness takes at trial. So, for example, you got a medical malpractice case. Person died of a pneumothorax. The doctor in the ER didn't do a chest x-ray. You're claiming that it should have been done. The defense calls a witness who said there's no need to take a chest x-ray. But you're able to bring out the qualifications, the guidelines, the American Academy of Radiology, and you can say to the witness, well, you're a member of the Academy. They promulgate guidelines, don't they? Yes, they do. In fact, really smart people in your organization, they promulgate and they establish these guidelines. Yes, and they are evidence-based. Yes, they are. In fact, they even kind of pass them around to everybody and let you folks even give your comments back, right? Yeah, they do. The guidelines say that chest pain is a sign of a pneumothorax, right? Yeah, that's true. That's what they say. And they say that a chest x-ray is the way to make that diagnosis. True? Yes, that's true. They also say if you don't take a chest x-ray and a person is discharged from the hospital without the diagnosis of pneumothorax, then there's a 67% chance that person's going to die within a day, right? Right. So that collection of extrinsic evidence, when they put it all together, implicitly is inconsistent with the position the witness is taking at trial. Concessions of the witness, another form of inconsistency. So the witness has said A, and you're able to get various concessions from the witness that collectively are implicitly inconsistent with the position that the witness is taking at trial. An example, a witness comes in and testifies, the light was green. But you're able to say, well, Mr. Smith, you're nearsighted, aren't you? I am. That means you see things that are close to you really well, but you have a little trouble with things that are far away. Is that right? Yes. Wear glasses? I do. Did you have them on that day? I did not. And while you say you're observing this light, your 3 kids were in the back seat fighting over an ice cream cone, were they not? Yeah, they were. You were pretty concerned about the mess they were making in the back seat, right? Yeah. That collection of concessions is implicitly inconsistent with the position the witness is taking at trial. What a witness doesn't know. What a witness doesn't know. You put a series of I don't knows together, 3 or more. I do everything in 3s and above. Until you have 3, don't bother doing it. But you can have a series of I don't knows that collectively, implicitly are inconsistent with what the witness is saying in the position they are taking at trial. We tried a hip, an ASR hip case manufactured by Johnson & Johnson, a defective hip that got implanted into 5,000 people and they had to have them taken out. So it was a defective hip case. We tried the case in Chicago and the defense put on a witness to say that the design of this implant was not a defective design. But then the witness wandered into the pre-market testing area and testified that the pre-market testing was reasonable. Beyond just reasonable, he said the testing was robust. So I knew the pre-market testing piece of the case very well. I knew this witness very well. I knew the witness didn't know all that much really about the pre-market testing. But he ventured into that and gave this opinion. So I put up on the board, I wanted his exaggeration, not only reasonable, but it's robust. It's right big on the board. And I said, well, they were like 10 different size implants, right? He said, well, yeah. I said, well, in the pre-market testing that you say was robust, right? This is what I'm doing you wrong. That was robust. Which size implants did they test? Well, I don't know. Did he test the 33 millimeter? I don't know. The 55? I don't know. The 122? I don't know. I took one, I don't know, and put it into 4 questions. And then I looked at it and said, well, they put it on a simulator pre-market to test it, did they not? Well, yeah, and that's to simulate a person's steps when they walk, right? Well, did they test it in that simulator pre-market, this robust testing? Did they run through 1 million cycles? I don't know. 2 million? Well, I don't know. What about replication? I mean, when you scientists are testing you, you kind of want to replicate. How you do a test and you get a good result, you want to do it again. You want to replicate it to make sure that it's accurate, right? Yeah, well, yeah. Well, how many times do you replicate the simulator? I don't know. How about the credentials of people that they put these tests together? I don't know. Were they tribologists? I don't know. I mean, robust testing. And so a series of I don't knows can implicitly be inconsistent with the position the witness is taking. Then more low-hanging fruit. Every once in a while, you'll get a case where the person simply does not have the background, the credentials, and the training to be taking the position that they're taking. I once handled an obstetrical malpractice case involving the breech delivery of a baby, so the baby's coming out feet first. The defense called an expert, an obstetrician, said, well, what's your experience with breech babies? He said, well, I was one. and that was it. We're involved in, Dan Getz in my office, we're involved in a case, and I'll talk about it a little bit more. We're maintaining that paraquat, used by farmers. It's a spray, it's an herbicide. We're maintaining causes Parkinson's disease. We're not like maintaining it does. So this is being recorded, not maintaining it does cause Parkinson's disease. The defense called a witness, they had a toxicology lab at Brown University, a highly credentialed woman. And she was coming in to say that some of these animal tests that we are relying upon were of low quality. But I was able to say, well, these animal tests, these are mice and rats, right? Yeah, well, you ever done a mouse study? No. You ever done a rat study? No. You just study zebrafish. Yeah, I study zebrafish. What about paraquat? You have any NIH grants? Study paraquat? No. Did your lab study paraquat? No. Have you ever done a paraquat study where you intoxicated any animal paraquat? No. And the same questions repeatedly. Again, this collection of the lack of credential, background, experience, implicitly inconsistent with the position being taken. So, we're going to hold until the end, but you're a special person, Blake. Yes.
How do you like to memorialize the I don't knows, the concessions, the do you like to write them down as you go? What do you like to do to bring them around?
Part two. We're going to get to that because it's worthy of discussion because I differ from some of the folks. I differ from Mark Lanier.
Okay.
I have a different viewpoint. So rules of cross-examination. Rules is an overstatement. There's so many exceptions to what I'm going to talk about. I shouldn't call them rules. Cross-examination is an art. It is not a science. So real experienced folks here are going to tell you that, interesting, Eric, but they ain't a rule. But I call them rules anyways. My number one rule, and it's first because it's most important. It's first because it's most important. You need to prepare the Drew Brees way for your cross-examination. Drew Brees, future Hall of Fame quarterback for the New Orleans Saints. I was at an awards luncheon. I had the opportunity to sit next to him at the table and talk to him. I said to him, after lunch, I said, look, Mr. Brees, he's 30 years younger than me, but he's in the Hall of Fame. I said, you NFL quarterbacks, you're all freaking great athletes. And you're all big, you're all fast, you're all strong, you can throw a ball a mile. I mean, what's the difference between a good quarterback and an NFL quarterback? And he looked at me a little quizzically, he said, preparation. I said, he goes, you don't understand, he said, during the week before a game, I sit down and I go through in my mind every single play that I'm going to call in the game coming up on Sunday. If I call, WXZ 25-6, I think, well, if the defense puts 3 linebackers in the box and they go man-to-man coverage on the right and the zone on the left, I'm going to do this. But if they go with 4 safeties crowding the top of the field, and they got all the linebackers in the box, I'm going to do this. If they do this, I'm going to do this. You prepare a cross-examination. You got to go through every single question that you're going to ask. And then say, okay, the witness says this, I'm going to do this. The witness says this, I'm pulling this document. The witness says this, I'm pulling this testimony. Every question. Every question. Here is a sheet of paper. This is from a legal pad from a cross-examination that I did. The head of testing, the head of testing at Syngenta Company that manufactures Paraquat. Now, what had happened in this case is a woman by the name of Louise Marks had done a rat study in 2003. Well, they intoxicated a rat. They intoxicated a rat with Paraquat, and it did not damage the substantia nigra pars compacta, the part of the brain where Parkinson's disease lives. So they loved the results of this test. They did their own lab. They loved it. But Marks sends this email internally that says, hey, our methodology for this test, our counting actually, the counting was flawed. We really gotta, be thinking about these results. We have a flawed methodology. Well, what they did was, despite this internal acknowledgement of the flaw, they wrote up a poster presentation of this test, which is a summary, basically a one-page poster summary of the test and these wonderful results, the results they loved as lack of damage, and they published it at the International Society of Toxicology meeting with toxicologists from all over the world. And so here's my cross. My cross was, of the person, the head of testing. I said, well, Syngenta presented this flawed results of the Mark study at the International Society of Tox meeting. Well, if he says no, well, then I'm going with T26. And T26 is his deposition. On that page, that line where it says we did present it. But I said, well, if he says we did present it, but the poster itself explained that we had this flaw, then I was going with Exhibit 356, which was the poster, so that they didn't say it. And then if he says, well, it wasn't in the poster, but she was standing right next to the poster explaining to people as they came up that there's a flaw here. He said that I was going with another piece of transcript from Louise herself saying, I wasn't there. But if he says, well, after the fact, we contacted them and told them, hey, there's this flaw. You better let everybody know it was at the meeting. Then I was going to ask this series of questions. That's one question in a 6-hour cross-examination. One question. It's the Drew Brees way, and it's the only way, in my opinion, to prepare a cross-examination. Discovery. Law students, I don't know if you know what a deposition is. Before, on the civil side, before we try a case, we get the opportunity to take a deposition where the witness comes in, you think it's going to be called the other side, you ask them questions and whatnot, what are they going to testify to, you can ask them all sorts of things under oath. You get to do that before the trial. My advice to you is, don't do your cross-examination during the discovery deposition. It seems obvious, but folks do it all the time. It's as if they can't help themselves. They just can't. It's like a Thursday hero. It's the person that is great in practice on Thursday and sucks in the game on Sunday. I mean, this is practice. Practice, practice, Brian. Alvin Henderson. It's just practice. You don't do it. And a variety of reasons. Number one, if you do your cross-examination during the discovery deposition, you've previewed everything you're going to do at trial. When you get to trial, the witness is going to be totally prepared to answer all those questions. That's number one. Number two, you do your cross-examination during your discovery deposition, and you do it well, you're going to make the witness and their lawyer, you're going to make them anxious. Anxiety ain't a good feeling. People avoid it. So to avoid it, you've given them the incentive to prepare like crazy so that they're not made anxious in the trial. You don't want to do that. You want somebody leading. I can't tell you, I take depositions, people that you went, that Kennedy sucks. They're not going to do that deposition. I mean, that was easy. I thought he was supposed to be a good lawyer. That's the way you want them to leave. Because now they're comfortable. And comfort leads to anxiety. Comfort leads to the lack of anxiety. Comfort leads to arrogance. And arrogance leads to a lack of preparation. And the lack of preparation gives you the opportunity to do an effective cross-examination. So don't do your cross-examination during your discovery deposition. Oh, talking to the dog. You ever notice when you talk to a dog, it doesn't matter what you say, It's just kind of how you say it, I love you, Rover. Come over here, I'm gonna give you a treat. Rover's, heading out the freaking back door. Or you can say, hey, Rover, you're a horrible man, little girl. Come on over, Rover. And Rover's like in your hand. You gotta talk to the dog in cross-examination. Now, I'm not saying abandon substance, but I'm saying you gotta talk to the dog because you're communicating with the jury. You're communicating with the jury with everything. With the tone of your voice, with how loud your voice is, with I approach the witness. Now the jury's listening as if we're exchanging some confidential information, so they're sitting up to listen. What's going on between those two? I can show disrespect. I can ask you a question as I walk away from you. I'm going to show you disrespect the jury understands. Or I can stand up here and I can look right at the jury and ask you questions. The jury understands this is coming between me and them, and really not you. Pause. Pauses are talking to the dog. I can have a great big huge pause before I ask a really important question. The jury's catching up. They're paying attention. Something important is going to happen. Or I get a great answer. And now I'm going to pause too. I'm going to let it sink in. Sometimes I get a great answer and I come back to the lectern and I think like I'm writing it down. Wow, that must have been freaking important. He's writing it down. Sometimes if I got a wildly important question, I'll be up here questioning witness and I'll go over here and I'll get my pad and I'll kind of bring it over and I'll read the question word for word. It's like, wow, that question's so important. He doesn't want to even screw up a single word. He's reading that one. That's all talking to the dog. Every aspect. And you've got to do it. I mean, Professor James McElhaney, Steve, I couldn't come here without talking about him. He was Steve Miller's professor here. He was my professor here. Nationally renowned trial advocacy lecturer, author. He often said, the purpose of cross-examination is for you to convince the jury that you're a better witness than the witness. And that's what you're trying to do. You gotta have substance in your questions, and you need to talk to the dog. Leading the jury to the conclusion, then stop. This is hard to do, because we all want to seal it up clean. But you gotta lead the jury to the conclusion and let them draw the conclusion themselves. But you've led it there. There's not much question the conclusion they'll draw. You've led them there. But you got to allow them to draw it themselves. You can't ask that additional question where the answer is in the question. You can't do that. Because jurors are human beings. And human beings are egocentric. And because of that egocentricity, we tend to hold on to our conclusions much tighter than we do conclusions that are imposed upon us. So you have to let the juries draw their own conclusions. In addition to that, you don't want to piss them off. Because understand, when a jury arrives at the courthouse, they go into some big auditorium where all the other jurors are there. They ain't all that happy to be there, but a court administrator comes out and says, hey folks, you're the jury, and guess what? The judge is going to do the law, but you folks are going to make the decisions. You're going to decide the facts. You're going to draw the conclusions. And then jury selection, the first thing that happens, the judge comes out and says, you're going to decide the facts. And the plaintiff's lawyer gets up and says, you're going to decide the facts. The defense lawyer gets up and says the same thing. And now you get in the middle of the trial, and you're going to draw the conclusions for him. It's like, what? You told me that's my job. And it is. Let the juries draw their own conclusions. You don't want to draw them for them. I got a drunk driver case I'm suing, and I've got the driver on the stand. So I'm going to say, hey, before you went to Bill's bar, you were home? Yeah. About 4:30 in the afternoon that you left? Yes. And so at 4:30, you didn't eat dinner before you left, did you? No, I didn't. When you got to Billy's, did you get a table? No. You went right and sat down at the bar. Did you order dinner? No. What about those wings at Billy's? They're famous for their wings, right? Did you get them over wings? No, I didn't do that. You just ordered a scotch, right, with one big ice cube, right? Yeah. And Billy's has got those little bowls of peanuts in the bar where people can kind of reach in with their hands and grab them. You didn't do that. Germs is kind of a thing with you. I didn't touch those at all. before you finished that bourbon, you had a shot of bourbon on the side, didn't you? Yeah, I did. Then bourbon's done, you had a beer, right? Yeah. Second beer? Yeah. And during the second beer, the bartender's Sally, right? You and Sally are friends, right? Yeah. Sally ordered you a shot, one for herself and one for you, while you're drinking your second beer, right? Well, yeah. When that was all done, just kind of for the road, you had another scotch, right? With that big cube, yeah, you did. And decided it's time to go home. Yep, about the seventh there, yeah. And you know that Sally says anyway, I just stumbled. You remember that? Well, no, I don't remember that. You're not denying that, no. Then you got in your car. I don't ask, and you were freaking drunk. I don't ask that. You were impaired. No, you shouldn't have gotten in your car, right? No. No, you led the jury to the conclusion. Let them draw the conclusion. And it's theirs. And they hold it tighter when they get into their room to deliberate. Normal cross, again, normal cross, you're destroying credibility if you can. That's the normal cross. But before a witness testifies, you need to sit down and say, okay, what is this witness going to bring to the case? What are they going to bring? And maybe you conclude that I can get more good things, more good concessions than bad. And if you make that determination, which is rare, because it means somebody's calling a witness they shouldn't. But if you make that determination, you can get more good than bad, then you probably want to bolster the credibility of the witness and not attack credibility. The other school of thought is no. I think you want to get the good things and then attack anyway, just to make it clear to the jury you're not on the same team, that you're getting these good things from somebody from the other side, because they'll carry more weight. Safer to build credibility, but interesting that maybe you do want to attack to make what you get more value. That's the exception. You don't run into this very often. Yogi Berra. Yogi Berra was a catcher, Hall of Fame catcher for the Yankees in the 50s and 60s. Probably more famous for what he said than his playing days. Yogi Berra once said, if you don't know where you're going, when you get there, you will be lost. It's the same with cross-examination. If you don't tell the jury where you're going, when you get there, when you make your point, they'll be lost. You gotta tell where you're going. So if I have let's say, a failure to warn case, the defendant didn't warn of danger A and Mrs. Smith got hurt. And I've got the head of safety of the company on the stand. And I could say, hey, you knew of danger and risk A, didn't you? I did. Did the company know? The company knew. And you failed to tell consumers. True? Yes. Jury's kind of lost. I didn't tell them where it's going. You need to tell them where you're going. So you start with, well, Mr. Smith, you're the head of safety for this company, for ED company, you're a bad company. You're the head of safety, you're not, I am. And you understand that as the head of safety, your company's got the duty and the responsibility to warn consumers of risks and dangers that you know about. You've got that duty. You agree with that? Yes. Would you agree that consumers out there, like my client, Mrs. Smith, she's got the right to trust that if you know about a risk or a danger, she's got the right to trust you're going to tell her, right? Yeah. And if you fail in your responsibility to tell folks about folks about risks and dangers you know about, if you fail and they get hurt, that's on you and your company, right? You knew about risk A, didn't you? You did. And you didn't tell consumers, did you? I told where to go. And when I got there, they weren't lost. So remember, you gotta tell them where you're going. Oh, you gotta know your witness. This seems obvious, like, don't do your cross-examination during the deposition. If you think about it, the conversation, it's not a conversation, but the interaction between you and a witness during cross-examination is one of the more intimate exchanges that you're ever gonna have with another human being. I was married for 25 years, and trust me, I can still say that. It's like one of the most intimate exchanges that you'll ever have. I mean, think about it. It's just two of you. It's just two of you. And you're trying to make that person look stupid. You're trying to make them look unprepared. You're trying to make them look not credible, dishonest. And they're trying to do the same thing to you. So to not know and have an understanding of who that person is, it's crazy. And there's so much information out there. I mean, you can look at the internet, what's their social media profile. Most of these witnesses have testified in multiple cases, even prior depositions. You can take their deposition in this case and get a feel for who they are. They might be the I don't know witness. Some people, when you kind of corner them, make them uncomfortable, they go right to, I don't know. Maybe that counts. And then you need to know that, because then you're going to put a string of I don't knows together. It might be a witness that when you kind of make things a little difficult and tough, they just start to give you these long-winded answers that have nothing to do with anything, like watching a congressional hearing or CNN. I mean, nobody's answering the question. Maybe it's that kind of witness. You need to know, because that's a different preparation. Maybe it's a witness up on the left that gets angry. You need to know that too, because if you can create anger, that's so unattractive in a witness. So when I take my deposition, I try out a few things to say, hey, is this person wrong? And if I find that there's a couple little buttons I might push, I'm pushing them during my cross, because I want anger from that witness. That's not attractive. And then you'll have the A versus B. The witness just has no problem with lying, just giving you bullshit. They got no problem. And that's a different witness. You need to prepare differently for that witness. So you've got to know your witness, because it's a different preparation, depending on who the witness is. All right, now, this is interesting. So we talked about Mark Lanier. Great lawyer. Dan in my office is trying cases with him. Somebody that I've known for years. And, making the jury part of the show. And this is really kind of what he does. He makes the jury part of the show, particularly on cross-examination. So he's an Elmo guy. So he's got his Elmo. And he asks the witness a question. And the witness gives him an answer, and then he gives a summary statement of the witness's answer. So he's asking questions, isn't it true you've got a duty to warn? Yes. And so he's got the witness's name in the top of the Elmo sheet of paper and the date, sometimes a little picture of their head. And you got the responsibility to warn. Yes. Witness admits responsibility to warn. He writes it down. And you didn't warn. Witness admits, they didn't warn. So he's writing all of these answers down to pretty much every question in a summary statement fashion with the Elmo. And then in close, he takes the Elmo sheets of papers and he puts them up on the screen, and he does his final argument basically around what he wrote on the Elmo, which are summary responses of each answer on cross-examination. Now, it's wildly effective. It's wildly effective for a couple of reasons. Number one, the jury during cross and the jury during close, they're seeing it and they're hearing it. All right? We all know if you see it and hear it, you remember it better than what you just hear. So it's got that advantage. Secondly, when you put that up in close, the jury knows that it's accurate because they saw you create it with the witness. So they know it's accurate. And third, in a very interesting way, the jury feels like they're a part of the creation of that exhibit and those summary statements. It's like somebody who says, hey, I was at Woodstock. I saw Taylor Swift on August 15, 2025. I was at the 7th game of the World Series, when the Cubs beat, the Indians. It's like, they didn't sing a song, they didn't play the guitar, they didn't throw a pitch, but you were there. You witnessed it. You feel part of it. And like I said before, if you feel part of it, because of that egocentricity, you're going to hold tighter to it. It's going to have more meaning to you. So it's tremendously effective. But, and Dan Getz in my office disagrees with me on this. We argue over this a lot. I think it has a downside, a bit of a downside. Number one, if I'm writing a summary statement on the Elmo for every question, it takes a lot of time. And you only have so much time to entertain and keep people's interests. I see you guys are fading a little. I'm gonna end this soon. You only have so much time. So it takes a lot of time. Secondly, if you're writing the answer to every question, then you're not highlighting it. You're highlighting everything and therefore nothing. Then in addition to that, you got the Elmo, and you're standing behind the Elmo. The witness is over there, the jury is over there. And you become a little bit like, to me, you become a little bit like the Wizard of Oz. They hear your voice, they see the writing, but they can't see you. You're behind the Elmo. And so what you're losing, to me, is you're losing that physical interaction between you and the jury. And again, we're talking to the dog. And so my physical interaction and my body language is communicating to the jury. It's persuading the jury. And if you're behind the Elmo, if you're the Wizard of Oz, I think you lose that. I have a watered down version of the Mark Lanier methodology. What I do is I don't use the Elmo. I'll use a flip chart. I'll use a flip chart or one of those big electronic boards where you can write on it and then save it. And then I bring the flip chart back up and close, or I bring my big electronic board back up and close. So number one, I got the advantage seeing and hearing. I got the advantage when the jury sees it and close. They go, well, that's accurate because we saw him make it. But I also have the advantage that I'm out front. I'm still communicating with the jury. They're still seeing me. And then I'll go over my ease and I'll write. But I'm approaching the witness. I'm pausing. I'm moving back. And so I think it's the best of all worlds. This is from a case down in Florida that we tried in January. Tried it for 2 weeks and got mistried the day before we closed. So that's really not a very good ending. But, and this was a pressure cooker case where a company manufactured pressure cooker. They were exploding. And our client had exploded, third-degree burns from her chin to her belly button. And they had 900 of these pressure cookers explode before our clients exploded and injured her. And when it would happen, they would get the pressure cooker back, they'd get the consumer to return it back to them, and they would do these relatively sophisticated engineering analysis on the cookers to try to figure out why they exploded. But when I was cross-examining the head of this testing program, I was able to establish, and this is my handwriting on my flip chart, that Pratt's was doing testing, and he wasn't even an engineer. He was just a high school grad. And the next guy, he wasn't even a registered engineer. The next guy was an English major. The next guy was still a college student. The next guy was still a college student. And another person was an IT major. And I thought this was great. I mean, they've got these folks, doing these engineering analyses. So we're getting ready for close, and this is a picture from my flip chart. We had our graphics people in our war room create this beautiful piece, outlining the testimony. Then we all kind of sat around and said, well, which one are we going to use, everybody? What do you like better? Did you like the handwritten version where the jury saw it created? Or do you like the more refined, thing that we did with our graphics people? And based upon everything that we've talked about, this is what we chose to use had we not been mistried and been able to get them close and use it. But again, that's the jury. They were part of it. They saw it being made. They know it's true because they saw it being made. I've got, the seeing and the hearing, and that's where we went. And I think this is a really nice way to do a cross. Some of you may think you do every question with an Elmo, like Mark Lanier is wildly, successful. I like to water it down a little bit and do it this way. All right. Last slide before happy everybody. Don't get in the cage. This is really hard. It's really hard to not get in the cage. You don't want to get in the cage, because that's where the bear lives, all right? And the bear will make your day miserable. The bear will make your life miserable. Don't get in the cage. The bear is that part of the witness's testimony where the bear's right. No witness is wrong in everything. Otherwise, nobody called it. There's going to be things where the witness is really right. And it may be a really important issue. It doesn't matter. That's the bear. The bear is also that area of the witness's testimony and background where they are really an expert. They know more than everybody in the room. You don't go there either. So you don't get in the cage with the bear, right? And where they're smarter than anybody in the room. What you want to be is the lawyer outside of the cage, poking them with your stick of inconsistencies that we've talked about. That's what you want to do. I saw a lawyer cross-examine an expert. Spent a half hour talking about the misrepresentations in their curriculum vitae. Half hour. And sat down. Didn't touch the substance where the witness was really right. It didn't much matter. It didn't much matter because they weren't telling the truth on their curriculum vitae. It's the beef stew analogy, by Professor Macker. Then you get them close and say, hey, you know what? My father loves beef stew. He went to this famous restaurant. They're famous for their beef stew, and he got the beef stew, and it came out. And the first bite he took, that piece of beef, it was rancid. Well, what was he to do? Was he kind of obligated to pick through that beef stew and try to figure out what's rancid and what's good? Was he entitled to send the whole bowl back? Professor, Schwabnitz, to everybody on his curriculum vitae. So what are you supposed to do with the rest of his testimony? Do you have to pick through it and try to figure out where he was telling the truth or where it wasn't? Or are you entitled to send all that testimony? Send all. Thank you.
Okay, we promised question and answer, you all held on. So, we can do this a couple different ways. I don't need to stand in front of them. I'm gonna stand to the side and call people as you raise your hands. If anyone has questions that you want to start asking. I know he promised happy hour, but we still have 25 minutes if we have a flood of questions. Go ahead.
So in light of your theory about, the linear, whatever, so back to as you're establishing these inconsistencies, would you put that on a flip chart? Would you write it down? Or tell me how you would, so you've got a witness and he's either doing the I don't know, or you're pointing out that he has inconsistencies. How are you memorializing it?
Yeah, again, it's not every question, but I'll take 3, depending on how many crosses. If in an hour cross, 2, in a 5 hour, 4. I'll use my chart and the important ones, and I'll go right on down. Those inconsistencies, I'd be, doesn't know number tested, doesn't know size tested, doesn't know if they replicated, doesn't know the protocol. I'd write them all down. If I think that's going to be a really important part that I'm going to want to use and close. So I'm not doing them all, but I'm charting right in front of them. 2 things: they're seeing, they're hearing it. It's got crazy credibility to close because they go, well, that's accurate. He made it. And again, there's that weird thing about they feel part of it, and it's an interesting psychological thing. So that's what I do. I like the chart and I like the big boards more than the element.
Okay. Because you have other people carrying your shit to trial.
You also have really nice handwriting.
In the back. Yeah.
Mike, you were talking about a witness, a CEO who is on the stand, and you might have to deal with damages. If the CEO is adamantly denying any liability, do you put the damages portion in the middle of the testimony? How do you bury the damages. You don't wanna leave the, damages at the end, do you?
Reality check is that in the vast majority of cases, you got the CEO or somebody at that level, that's not gonna be the person who's even talking about damages. I'm not touching damages with a 10-foot pole with her. But in this scenario, we may have to. And your question, David, is where would I put it? I wouldn't lead with it, and I certainly wouldn't end with it. Yeah, I guess the answer is I would work it in somewhere in the middle. You'll see tomorrow. I don't spend a whole lot of time on the damages issue. By the way, I'm just dying to ask, how many people in the room think that preparing for a cross-examination is more fun than preparing for a direct examination? Do it. Who looks more forward to doing cross-examinations than direct examination? Every experienced trial lawyer in the room is going to raise their hand because it's a lot more fun. It's not necessarily more important, but it is a lot more fun.
Eric, most cases settle. Your practice probably tries more cases than some other category. But I go to your comment, you don't do your cross-examination on deposition. But don't you have to evaluate your case as you're doing your discovery? And say, is this case really likely to go to trial? Or what should I be doing to set it up for a more favorable settlement, if that's the way you think the case is going to go or could go?
I agree with you. I mean, there are depositions, we call them settlement depositions. I mean, it's gonna settle, you're close, you need that extra piece to finish it off, and I'll go and I'll cross. But most cases, you're taking a deposition early so you don't know. You know who your opponent is, you know the case, and so you get a feel for what's going to settle and what isn't. But I always err on the side that I'm going to try the case. And I can tell you 100% true, my best settlements come when I am ready to freaking try the case. And that might be because my opponents, I've showed so much that they're frightened about the case, but I think it's more in my mind. It's so much easier to say no to money that's being offered to you if you're freaking ready and you believe it, you're ready to go. And I've got 4 things that they don't have a clue I'm going to do. But there are settlement depositions, but that's usually not the case, and it's later. But I've taken that deposition.
Piggyback on Jack's question, sometimes when you are taking the deposition of an expert witness, I know you don't want to give away all the cards, but aren't there times where you are scoring points and you are thinking to yourself, if this continues to go as well as it's gone thus far, I'm going to have a shot at a Daubert motion?
I mean, a Daubert deposition, that's a different deposition. What I do to prepare a deposition is I sit down and write my cross first before my discovery deposition. And then I figure out what do I need to do that cross. So if I want to ask this question, I say, well, I already have a deposition of this witness from 3 cases ago, and that'll back up that question. I want to ask this question, and I have an article that expert wrote, so I don't need to ask it because I've got it in an article. I just figure out what questions and what do I need to establish during my discovery deposition that allows me to do the cross that I've already written. And I go get those points. And they are not at all near each other that makes sense to anybody. If I need A, B, and C to be right together to add up to a point, I ask A in the first hour, I ask B in the second hour, and I ask C in the third. I mean, you just don't want to telegraph anything. I mean, I can say 100% of the people that look and read my deposition, people refer us a case, and they're all excited, we're going to handle this case and get a whole lot of money, and they'll come to the first deposition, they'll leave and go, what the fuck, why did I get this in my case? And I said, relax, we're all good. I got exactly what I need to do the cross I want to do. And I know it. So
I agree with what John was saying in some depositions. I think he's right. Most of the time, Eric, what you're saying is probably the way I would have looked at it. But then there are some, and this is to the point of listen to the witness and also know your case and know where you're going. Sometimes there are opportunities, even in the deposition you're taking, when you don't want to do the cross. When the witness says something you didn't expect, you got to pounce on it and maybe get the admission then rather than wait till later. So comment on that.
Well, look at it. As I said, these are rules. I mean, I call them rules. They're guidelines, and everything is so nuanced and so case. I mean, it just is. Yeah, I'll do a little bit of a cross just to see how the witness reacts. Are they going to give me out on those? Are they going to, be give me bullshit? Will they give me long-winded answers? Are they going to straight out lie? I mean, so you're doing some of it. They're generalized. I mean, every case is different, but for the most part, the majority of cases we handle, our attitude is we're getting ready to go try it. Because you get the best resolutions when you're ready to try the case. And I think that's just in your own mind, not the other side. You're ready. And so it's easier to say no to X dollars when you are ready to go. Because you're so convinced by the time you get to the first day of trial, you're ready. You're so freaking convinced you are right. It's easy to say no, but if you're not really prepared to go, resolutions aren't as good as they can be, to me.
And for the law students in the room, everybody's following this, right? This is the juxtaposition of discovery. He's talking about discovery and taking depositions as opposed to cross-examination at trial. Tomorrow, you're going to see a demonstration of an actual cross-examination at trial.
Actually, I have two. Is that okay?
One, and then I can come back to you if I have time.
So how do you integrate, and this one is more for Eric, how do you integrate your cross-examination tactics to the rule-based strategy that plaintiffs might often use to, increase their damages and kind of what we already saw happen in the open?
How do I use cross to make my damages bigger?
Kind of, like how do you loop it back to like a rules-based plaintiff strategy?
I look at damages in the vast majority of cases we try. They're not contract cases, and so there's no blue book, there's no formula, there's nothing saying you win, you get $100. Most of what we do is, what is the value of a father to a child? What is the value of a child to a father? What is the value somebody has to live where they can't even look at themselves in the mirror, their scarring is so severe. What are those values? And guess what? You don't know. I've been doing this for 45 years. I don't know. To me, that value is driven by two things. It's driven by, number one, is anger. People that are pissed off give people a lot of money. Two, people give more money to people they like than people they don't like. And three, I said two, but there's three. By the time you get to close, you're going to stand up and you're going to say, this is $1 million. The jury doesn't know. The other lawyer's going to get money. He's going to say, well, they should get nothing, but if they do get something that's worth, $15. The jury's got to trust somebody. They have to trust somebody. So if I can make them angry and I can make them love my client, I can make them trust me, I'm going to get the $1 million. And part of making them trust me, to me, is talking to the dog. It's interacting. It's McElhaney, making them believe I'm a better witness than the witness. And so it's that. You want to drive anger, you want to drive a love for your client, and you want to create that relationship so they trust you more than any other lawyer in the room. Those are kind of rules. Let's call them guidelines.
It's okay.
There's that old phrase that lawyers never ask a question that they don't already know the answer to. But if you are examining someone, especially cross-examining, and they say something that's truly unexpected, how do you keep your footing, especially in front of a jury?
In my view of the world, if you hear something unexpected, you didn't prepare well enough. If my witness on cross has to address and answer a question that they didn't expect, I didn't prepare them well enough. But if it happens, you have to be smart on your feet. I don't consider myself to be someone very smart on their feet. And I think that I know it. And down to we're preparation human beings. I'm a preparation human being. I'm comfortable if I'm prepared. I'm doing my job if I'm prepared. So I don't think you should be surprised, but if you are, you have to do something that I don't consider myself very good at doing, and that's thinking on your feet.
This is ironic, I've known this guy for a long time, I didn't know, we prepare in much the same way, especially that note on cross-examination, you know, the zigzag. If the witness goes here, then you be prepared with this, that's his version of the Drew Brees approach. I agree with it completely. You know your case, and if the witness says something that either it's expected or unexpected, if they go a certain way, you are prepared oftentimes with an exhibit or a prior inconsistent statement at deposition or otherwise to use it against them. Be prepared for that tomorrow, by the way.
Eric, this goes back to, and the way I was taught to depose a discovery deposition is also you never cross-examine someone in a discovery deposition, but you talked about using anger at cross-examination at trial. And of course, you're going to discover that anger when you're taking somebody's discovery deposition and they get pissed off. So my question is, how deep do you go in during the discovery deposition? Like if they get angry, do you immediately back off?
Yeah, as soon as I know I got a trigger that I know can make them mad, I back off. Because if you take it too far, the prep with the lawyer's gonna go, he's gonna go here. You got all worked up. You can't do that. If I see I've got it, I'm going. And when we talk about anger, I forgot to say this, when I've been talking to the dog, as the lawyer cross-examining, anger is like a rarity where you want to go. You don't go there. McEnany used to say, the French general who said, I'm going to go out and need my truth, but I first need to know where they want to go. That's cross. You don't go anger unless you are 100% convinced that that's where the jury wants you to go. And you better be sure, because it's not a good emotion for either. And also be very wary of this, and I have this problem, and I have to, take some deep breaths before I start always. You've prepared for months to do this cross, and you've read the prior testimony of this witness, you've read their article, and this is full of shit. He's freaking lying, he's getting paid a ton of money, and you hate him. You can't be hating on that witness first question out of the box. The jury doesn't hate him. They never met him. And he's just done a beautiful direct where he seems like a delightful human being, or she does. So you can't start angry because you got a right to be angry because you know who this person is. But they don't. So you never get angry unless you are really sure that you know the witness wants you to go. And I'll tell you a story, and maybe you'll get I shouldn't, because you should never do this. We're trying this ASR hip case in Chicago, and I had the CEO as the first witness, and he was a miserable guy. So the first witness CEO, I'm crossing, and he fought me on everything, and he was really not likable. And then his lawyer, the defense lawyer, gets up and starts the question, and suddenly it's like a light switch, because he is delightful and smiling and agreeable and wonderful. And then I get back up to recross and start to cross me. And I said, Mr. Angus, let me just ask you a question. Is it me? Is it me? You seem so nice to Mr. Sarver. Is it something I've said, the way I'm dressed? Objection, they're screaming, And the judge is laughing, the jury's laughing. And it was a crazy risk. But I kind of felt it was so obvious and noticeable that I was going to take the risk. And the jury loved it. They thought it was funny because it was just so true. But I was really sure that's where they wanted me to go.
Your witness is vulnerable to this angry emotion, which is a real problem, especially if you're at the CEO level. You need to make it stronger, like shit, her or him, a long time before you go into that. You can't let that happen in front of that jury, because you can't put that toothpaste back in the tube.
Mike, I appreciated your discussion about making the witness likable, making the CEO likable, warming the jury or the judge up to him or her. Can you comment on, and I know, you handle cases for foreign corporations where you will have a CEO or an executive who second language, and they clearly have an accent, and now they're in an American corporate. How do you do that? How do you use the barriers that sometimes comes from that to make that person likable to the jury of Peoria?
Do I need a translator in your scenario?
Well, you could use either one. I've seen them both, but why don't you talk about both of those?
I mean, I've used translators, and I think you need to be careful in terms of the translator that you pick, because that person, in a way, takes on the modification of the witness. And then when there is a language barrier, I mean, you spend a lot of time rehearsing and making sure that the witness is understanding the questions and following along. I haven't had it too many times, Steve. I'm trying to think. I had it once in an arbitration. We recently had it in some depositions down in Florida. The other thing that I'll tell you is, if you happen to be, Judge Sonnenberg is not, I don't think, of this ilk, but if you are in front of a judge who is what I call a shot clock judge, and you need help, either the witness has English as a second language and is struggling with it, or you need an interpreter, you need to ask for more time, because that just takes a long time. If questions or if Q&A is literally, question being interpreted by and it's more than double the normal time to do something, and be ready.
The only comment, I don't want to take up the time.
Yeah, I don't have a great answer.
In one trial, I had two executives from this company. One needed the interpreter, Italian. The other one could speak English well enough without it. So we did them that way. One with the interpreter, one without it. And the one with the interpreter, of course, each side had an interpreter. And so the question gets posed, the interpretation, then they argue over the interpretation, and then it goes eventually to the witness, and then the same argument coming back. What did the witness say? Well, this, and then they agree on it. I found that the jury gets really bored with that. And that is the risk with it. And the one who spoke the English did her best, and even though she struggled, was more likable. So, those are two different experiences.
Last question.
Mike, I'm going to ask Eric a question, but I guarantee you've got a counterpart to it. So I want you to answer it after Eric does. Eric, this is the room where it happened. We are in the room where it happened. You were a student sitting here. And the journey from being a student sitting here to being there is an unknowable journey for all of them. You've talked brilliantly about the art of examination, but foundational to that is getting from there to the practice, from there to where you are. You cannot leave this room without taking a moment to speak to these students about your key thought about the journey they have ahead of them if they choose to do it.
Well, my good friend Roger Sonnenberg is here, and he knows what I tell my kids, and I tell it to everybody, certainly young lawyers. There's just two things. One, work harder than everybody else. Two, say please and thank you. It means be kind, be a good person, be honest, and work harder than everybody else. I would say to you this, my daughters are, late 20s, like to talk to me about a balanced life. And I said, well, I live a balanced life, and they laugh. And to me, balance is Everybody's got a different definition of balance. If I work 12 hours in a day, I've spent 12 hours doing something I love doing. So, I mean, everything's good. And so it depends on what you love doing and how you define balance. And so I would say work harder than everybody else, say please and thank you. And you can only, to me, to be a trial, you have to love doing it. And then if you love doing it, it's simply not work. It's extraordinary fun, but it's exciting, it's competitive, it's creative, it's imaginative, it's social. It's not a place to me that you can Zoom. To me, you got to come in because the interaction between the people in the office, you learn so much and you bouncing ideas off and. Do you like the written one, or do you like the one that the graphics people create? What do you think of this? And what about this cross? Can you listen to this? Let's watch this video together. So to me, it's if you love doing it, you're just never going to work. So you'll have perfect balance because traditional play is play and work is fun. So yeah, you need to really enjoy doing it, but work harder than everybody else, and don't forget to please and thank you. And I will tell you what, I'm talking too long, but you say, that easy? Yeah, it's that easy. I'm serious. I mean, the lucky thing is, there's a whole lot of lawyers in America. We try cases all over the country. And I'll tell you what, there's a whole lot of lawyers that don't work that freaking hard. So if you decide to work hard, you're there. And I'll tell you something else. There's a whole lot of lawyers that don't say please and thank you. They're not straight with you. They're not kind to you. They're not trustworthy. So if you take those two things and you work hard and you say please and thank you, I guarantee you, you're going to be successful as a trial lawyer. I guarantee it.
He said, I agree with everything that he just said. The harder I work, the luckier I get. It's just as simple as that. I love what I do. I wouldn't recommend this for anybody who doesn't love what they do. It's too hard. But I've enjoyed really every minute of the practice of law. I learn new things in every case. I meet really interesting people on the same side of my cases, on opposite sides of my cases. I learn things from my adversaries, and I just love what I do. I was reflecting on this. I'm maybe one of the few here who did not matriculate at this great law school, but I feel like I had a little bit of learning by osmosis. And I was lucky as hell. I feel like I transitioned from being the kid who looked forward to Mad Magazine arriving, in the mail when I was a kid to once I became a practitioner. What did I look forward to? I kid you not. I looked forward to the Bar Journal arriving once a month. Why? Because, and he talked about it, and you talked about it, Steve, it had McElhaney's thing in it, right? And it was unbelievable, right? And everything was Angus, right? Angus says this, and Angus says that, and it was all the things. Some people are wondering what I'm talking about, but it was just an unbelievable force of nature and inspiring to read in terms of this craft that we call the practice of law and the art of trying cases. And I would read it, and I could hardly wait to see it in action. And he inspires me to this day. I mean, does everybody know what we're talking about? I mean, McElhaney's trial notebook, I think, is legendary. There are only two. There's Malik, Fundamentals of Trial Techniques, and McElhaney's trial notebook. I would not recommend that anybody go to trial without having both at your immediate disposal. I use them in prepping for today, and Christina used McElhaney in preparing for today's remarks. I think it's borderline malpractice not to do so. This guy was unbelievable. I mean, just a force of nature, and he happened to be right here in the city in which we all call home. And for a while, he was local. I mean, he immediately got noticed, which was to no one's surprise. He was like the Taylor Swift in his day. I mean, he was local. He was singing only country music. He was writing for the Cleveland Bar Association Journal, and next thing you know, he's in the big leagues. Steve might have something to do with it. And all of a sudden, he's writing for the ABA Journal, and everybody said, the entire country that does what we do for a living then knows what an unbelievable coach he is.
And he was a nice man.
And he was a nice man to boot, right? I mean, on top of everything else. So, you know, and I think almost everybody who is an alum of Case Western Reserve Law School who has been part of this, you know, program have pretty much had the same revere and regard for them as Eric and Steve have expressed. Anyway.
Very true. All right, so today we're going to end with that, and I thank both of you very much for your wisdom. Please come back tomorrow morning. 8:30 there'll be some breakfast items, and 9 o'clock the program will be here.
9 o'clock?
9.